1575 West 10th Avenue, and considering a motion to convene a
Uh,
meeting which is closed
Chair, I
to the public.
lost audio. Anybody else have audio?
Hang on, Councillor Fry, we're just going to check.
Meeting now?
I've
lost audio as well.
Can you hear me now? Just hang tight for a sec, councillors. We're just going to check the audio. They can't hear me.
Test, test.
Councillors joining us online, can you hear me?
Yes, can hear you now.
Okay, fantastic.
Loud and clear.
Thank you. So I'll just repeat that last section. This special council meeting was called by Mayor Sim under sections 2.5A and 14.5 of the procedure bylaw for the purpose of considering the report entitled Declaration of Manifest Error, Tax Sale of 1208 1575 West 10th Avenue, and considering a motion to convene a meeting which is closed to the public. This special council meeting is being convened by electronic means as authorized under Part 14 of the procedure bylaw. The City of Vancouver electronic meetings. As such, council members may participate in person or by electronic means. Video of council members speaking and vote results will be projected on the live stream when available. We'd also like to acknowledge that we are gathered on the unceded homelands of the Musqueam, Squamish, and Tsleil-Waututh people. We thank them for having cared for this land and look forward to working with them in partnership as we continue to build this great city together. Clerks, may we have the roll call, please?
Mayor Sim, not present. Councillor Kirby-Young. Councillor Dominato is in the chair. Councillor Bly is not online. Councillor Fry.
Present.
Councillor Montague.
Present.
Councillor Klassen. Councillor Meisner.
Present.
Councillor Zhou. Councillor Orr. And Councillor Maloney. You have quorum, Chair Dominato.
Thank you, clerks. Council is required to meet in camera today. The reasons and authority under the Vancouver Charter are listed on your agenda. Would someone like to move a motion to go in camera? Moved?
Second.
Seconded? All in favor? That carries. Thank you. Council will now take a recess to convene the in-camera meeting. We will return to council chamber to deal with the agenda item number 2 at 5 p.m. That's what I've been advised. And just for the councillors here, we are moving into Cascadia for that. And for the councillors online, are they joining a different link or continuing on this one? Different link. Okay, there you go. Thanks. Council, we are back in chambers and we are dealing with item 2 on our agenda, declaration of manifest error tax sale of 1208 1575 West 10th Avenue. Before we begin this agenda item, does anyone have a conflict of interest to declare? Hearing none, we'll move to speakers. And so at this time, we have, and sorry, let me check in before I move to speakers. To our staff, Grant Murray, did you want to address council before we move to speakers? Okay, so just, and do we have, just so I'm clear, clerks, do we have the speaker on the line? We do. Okay, fantastic. So we will start with presentation and update from our solicitor from Grant Murray. I'll turn it over to you. Thank you.
Good afternoon, Council. It's Grant Murray with the Legal Department at the City of Vancouver. As you know, this was withdrawn yesterday because we understood that the money was going to be wired to the city. It subsequently turned out that the money is not being wired to the city. It was, the instructions apparently were misconstrued and the money would have arrived tomorrow, which would be, of course, too late. There is a supplementary submission in the report that's before you, and it indicates that the heir to the registered leaseholder attended at the bank, gave the instructions. He resides in Washington State. They incorrectly were going to transfer the money tomorrow. The information was provided to the city after the report was withdrawn. That's when we discovered that they would not be transferring the money. We withdrew it because we understood that the money was going to be transferred. The bank has now canceled that wire transfer, and they were intending to provide a cashier's check to the for the appropriate sum to the heir to the interest in the property. The heir has decided not to travel to Vancouver to deliver the check, and that seems to me to be a peculiar decision for somebody to make. The estate of the deceased has not been settled after more than 9 years. The title to the property has not been altered after more than 9 years. Notices of the tax sale were provided to the council, to the heir while he had some counsel. But the heir has informed the city and other persons that he does not have a cell phone, a computer, email, or a motor vehicle. The city is unaware of any current legal counsel that he has that can represent him, and there appears to be valid reasons to question whether he appreciates the nature of the proceedings he is facing. That's in addition to what we had already suggested could be a manifest error as a result of the notices being given to his mother when his mother was dead. And so the position of the law department is that there is a reasonable basis upon which we could conclude that there is a manifest error, A, the failure to provide the notices in advance of the sale, and B, a question about whether he can appreciate the proceedings that he is facing. And one fact that I should clarify is that the city was first informed about the death of the property owner on the eve of the tax sale last year, but that was just in an email, and it was subsequently further evidence of the death came out. But that's all I have.
Thank you very much for that update. It's appreciated. We will move to our speaker and then I'll make space for councillors to ask questions. We have Smith Kamdar, tax sale purchaser, on the line to speak to the report. Legal has recommended that the tax sale purchaser have no time limit to speak to this report. As such, would a member like to move a motion to suspend the 3-minute speaker rule as outlined in section 7.5A, which is entitled Limits on Speakers of the Procedure Bylaw? So that's been moved. Can I get a seconder? Seconded. All in favor? And that carries. Thank you, Council. And so I will invite Smith Kamdar to address Council.
Good evening, Council members. My name is Smith Kamdar, and I'm the purchaser of the property that's in discussion today. First, I'd like to thank everyone in the process for giving me the opportunity to speak. Thank you very much. I completely understand the council and the city has the duty to make sure that the tax sale process is lawful, transparent, and fair, not just for me, but the community and the process itself. I'd like to submit to you that according to section 406 and 407 mentioned in the charter, the city has fulfilled its duty by sending tax sale notices and to the registered owner's address on file. There was no return on mail or no indication at the time that the owner is deceased. Legally, that means the notice was deemed properly delivered. a manifested error under section 445 must exist um, in sale or in proceeding to the sale, not in the form of a discovery afterwards. The city only learned the owner's death after the sale was complete, which means the sale process itself was valid at the time. Even if the estate owner's heir were informed later, they had the same opportunity to the redeem the taxes during the redemption period. They did not act and pay the due amount. What I'm trying to say is, in good faith, I participated in the tax sale with an implied understanding that I put up the money, I bid. If I win the bid, and if the property is not redeemed within the redemption period, I get to keep the title of the property, provided I pay the balance amount on the bid. And it has so happened at the end of the phase right now. Um, Section 445 gives all you council members the discretion to let this sale stand, and it's my humble request to please let it stand. As the participant and public participating in taxes, there's no wrongdoing on my part, and I would request you to examine the process, because according to the charter, the city followed the procedures completely through and through. So there is no case of manifested error according to me, and I would humbly request the council members to please examine that. I've also put forward a letter, um, submitted a letter, and I would really appreciate if the council members could review it before making any decisions. Um, that's mostly about it. I put down all of my savings and more, having faith in the system and the process and the essence. We know the you as in we know that notices were given. They knew about it even yesterday um, um, when the motion was withdrawn. I'd like to play a clip that what Grant said during that meeting, if with permission. Can I?
Yes, go ahead.
Thank you. So
the owner's heir knows full well that this would have been sold if it hadn't been redeemed by Tuesday. They've wired the money from a bank and it's on its way.
So out here it says the owner knew full well that the property needs to be redeemed and done within the time. Even today, Grant's been awesome and doing his due diligence, making sure the person comes here and does it. But as he said that even after that, after his follow-ups, he hasn't come and paid the check, even from Washington. Um, I would really appreciate if the council members would please examine this and please let the based on as in you have the power and the discretion to let the sale stand, and I really humbly request that the council does. Thank you very much.
Thank you very
And
much.
if you have any questions, yeah, please, more than happy to answer.
Okay, thank you. Thank you for addressing council. I'm just going to check in quickly with clerks and just confirming that council members can ask questions of Smit Kamdar as well as staff present, correct? Okay, great, fantastic. Okay, so hang on the line, Smit Kamdar, and we'll turn to, I'm going to advance Councillor Kirby Young for questions.
Sorry,
Thank
point of clarification, we're not asking questions of the speaker per our procedure bylaw. I'm waiting to ask questions of staff. Can you just clarify procedurally
I think
where we are?
we're just going to reconfirm that. That was the question I was asking, that we can ask questions of the speaker in this context.
Maybe we can stop my clock while we find
Yeah.
out what the
We'll
procedure
pause
is.
the clock, clerks, and we'll get clarification from legal. Thank you.
Questions as well.
Okay, thank you, Grant. So Councillor Kirby Young, yes, there is an ability to ask questions of the speaker.
I have questions for staff, so I'll hold. Thank you.
Okay, so you just have questions for staff at this time? Okay, I'll go ahead then.
Okay. My question is obviously an unfortunate situation by all accounts, and I know that the city wants to ensure that we're being considerate of individuals and individual rights and situations. In the event that this tax sale was purchased, and we heard from the hopeful purchaser about that, can you just provide some clarity and assurance in that situation? Again, I'll say an unfortunate circumstance, but perhaps maybe viewed as a responsibility of the city. Can you provide some assurance that the purchaser would be made whole, so any of the funds or monies that they had advanced would be returned to them?
Yes, if the manifest error is declared, the rule in the Vancouver Charter is that the monies that he's paid to the city and 6% interest will be returned to the purchaser. He will not be out of pocket any expenses as a result of the manifest error declaration. He may have spent some other money on other matters associated with this, but he will be redeemed all of his money and 6%.
Okay. And what I'm hearing, and I just want to understand that I heard correctly, is that you're proposing this course of action because we feel that an individual may not have sort of the full possession or ability to kind of comprehend the situation. And we probably have a duty of care to ensure that we're providing full fairness for the individual to exercise their rights. Is that a
Yes, I think that's a fair characterization. It seems odd that he appreciates the nature of the proceedings he's facing if he is willing to forego approximately $1 million for the sake of traveling to Vancouver. But that seems to be a peculiarity that we've just recently discovered. There was, of course, the notices that were provided to his mother. They were done in accordance with the rules, but they wouldn't have been done in the spirit of the law, which is to actually inform the person and the person who is aware of what actually this means. So,
okay? And final question is, if the council were to cancel the tax sale, would the hopeful purchaser that we've heard from and received a letter from in terms of it's very meaningful for him and his daughter, would he have an opportunity to attempt to purchase it again? Should it go to market?
if it is sold at tax sale again, he would certainly have an opportunity to bid on it again. And yes, that's true. In the event that it is sold at a tax sale in the future, he would be entitled to bid on it, as are all members of the public.
Okay, thank you.
Thank you, Councillor Kirby-Young. I think Councillor Montague, I think, was ahead of me. That's okay. Well, I'll go ahead then with a question. Could I just get some clarification just with respect to the property? Is the property currently occupied by the purchaser, or is it occupied at all?
I'm not certain, but I understand that the heir to the owner has a telephone line in the condo, and I understand that he has visited Vancouver from time to time to attend at his mother's condo. I understand that it was subject to speculation and vacancy tax pursuant to the province. I don't understand that there's any empty homes tax being imposed on it, but I'm not certain about that. I believe that it's mostly empty, except when the heir attends at it.
Okay. Just going back to process referencing, I think a comment made by the speaker is just to reconfirm what I heard is that the heir did signal intent. He went to the bank to make the transfer. And while it wouldn't have made the time frame, it sounded like he had a clear intention of following through now that it's been identified that he is the heir. And is that fair to say, despite the cancellation at the last minute here on the transfer of funds?
Yes, he did attend at a bank, and he did instruct them to make the payment. But the payment was, from what I understand from the bank, they'd scheduled it to arrive a day late. And he was informed of this, and he was told that he could get a cashier's check, and he did not avail himself of that opportunity.
Okay, and he has no vehicle to drive up here to...
I believe he has no vehicle. He has no telephone. He has no email. He has no cell phone. He does have a home phone. I've in fact spoken to him at that address or at his phone.
Okay. Thank you for clarifying that. I will leave my questions there and advance Councillor Montague. Go ahead, Councillor Montague.
question for legal. You touched on this, but I just wanted to clarify. Can you maybe just explain a little bit further? My understanding is that yes, the city went through a process of notification, but the process of notification is it has to go beyond that. Would that be fair to say that there has to be an understanding or an assurance that the notification was actually delivered and understood?
There's certainly case law to that effect, that it has to be both delivered and understood to be effective notice. Sometimes, I think one of the issues here is that the significance of the thing also changes the nature of the process that should be involved. So just mere notice without it actually being understood as notice may be sufficient for a low caliber thing, but this is a $1.7 million property, and I think that highlights the amount of notice and the amount of process that should be involved in these things. But
Okay, I think that answers my
Thank you.
question. And my second question here. Have we sort of received information, or has there been a feeling from legal or city staff that at least recently, that this individual may not be capable of making a decision like this?
He certainly decided today not to proceed with something that perhaps could have been done, getting to Vancouver by midnight tonight. I have been informed by other council that they had questions about his capacity, but that wasn't anything. They're not in a position to assess that. We've had no medical practitioners review to determine whether he's competent or not. Part of it is just that the actions he's taking appear to be the actions that no one would take in these circumstances, and it raises the question as to whether or not he appreciates what's happening to him.
Okay, and he's the sole heir, is that correct?
That's what I understand in a communication that we received from council, that he had retained to get the estate processed, but no file was ever opened on that, and from what I understand, the property's never been transferred and the estate has never been administered.
Okay, thank you, Chair. Those are my questions.
Thank you, Councillor Montague. That brings us to the end of councillors with questions. At this time, I would encourage a motion. There was a motion, I just want to clarify, it is the report that is on our agenda. The motion there still stands from yesterday. That would be the motion to be made.
Yes, that would be the motion.
Council so wishes. So I'll look to council to move a, sorry, hang on, I've just got clerks, hang on. Just one moment, Council. So just to our speaker online, just to note that we have concluded our questions and you have had your opportunity to address Council, because we're noting that you have your hand up. So I'm just wanting to articulate that to you, and thank you for being on the line and to articulate your perspective, and for your letter. I will turn back to Council. I do need a motion.
Just a point of personal privilege, Chair, if we could get that on the screen so that we can see it.
Yes, so I will need a mover. Okay, moved by Councillor Klassen. Could I get a seconder? And I have a seconder by Councillor Zhou. So just to be clear, clerks are going to bring up the motion on screen. And then we can enter into debate and discussion. And for councillors online, just a reminder that when we do get to debate, discussion, and voting, we will require you to have your screens on. So just while the clerks are bringing up the motion that's been moved, it's disappeared. Hang on. No, we're just waiting for the motion to be on screen. Thank you, clerks. So council, I just want to draw your attention to the screen. You will see the motion that's been moved and seconded that council hereby cancels the sale to the tax sale purchaser of the registered leasehold interest in the property known as 1208 1575 West 10th Avenue, Vancouver, BC. And so at this time, I invite any discussion. Okay, seeing none. Checking in with everyone online. Okay, seeing none, I'll call the question. And for, actually, can we have everyone vote on screen, please? Can we move to press on? Thank you. And I'll take a vote assist. Thank you. I'll take vote assist in favor, please. Okay, thank you, council. I'm just checking, have we got everyone? Okay. Council, that passes unanimously. Thank you. I will need a motion to adjourn at this time. Adjourned, seconder, all in favor? And that carries. Thank you. Thank you, council. Thank you, staff. And thank you, clerks.